All right, next is Jeffrey Simon.
Mr. Chairman and members of the committee, thank you for allowing me to speak. My name is Jeffrey Simon. I am a lawyer who has, for his entire professional life, represented people with mesothelioma. And I live in Dallas, Texas. What I wanted to demonstrate was what has happened in appellate courts in Texas from 2006 to 2010, with specific reference, though not exclusively, to Borg-Warner versus Flores and its impact on the court system, in order to demonstrate that we have reached imbalance that needs remedy. Number one, I want to point out that there have been a number of verdicts that were appealed over the years. The last time a verdict for a plaintiff in a mesothelioma case in Texas was actually affirmed on appeal was in 2003. Since that time, the results have been one-sided and they've been telling. The results show that from 2006 to 2010, there have been 12 appellate decisions in asbestos cases in Texas, at least that I could find. And the defendants have won all of them. They are 12-0. The plaintiff with mesothelioma or lung cancer or asbestosis is 0-12. The jury is 3-8. You'll notice that's 11 instead of 12. That's because the 12th on the list, the Smith case, was the appeal of a summary judgment granted for defendant. But not only is the jury 3-8, the three times the jury found for the defendant, all of those were affirmed on appeal. But the 8 times that a jury found for a plaintiff with mesothelioma or lung cancer or asbestosis, 6 of those were mesothelioma. In all of them, with every inference indulged in their favor, that being the standard of review, all 8 of them were reversed. Now, my point is not to impugn anyone in the appellate court system, but to simply say that there is something wrong here. The law is too difficult for plaintiffs with mesothelioma with meritorious claims. Because, of course, in all 8 of the verdicts for plaintiff, they being 2006 and later, the plaintiff had convinced through counsel Judge Davidson that there was a triable issue of fact, had convinced the trial court that there was a triable issue of fact, gotten through directed verdict and all the rest of it. And yet, when they convinced the jury that they were right on the merits, they were reversed every single time. Although not each and every one of these dealt specifically with the issue of Borg-Warner versus Flores, the impact of that decision can't be missed. The committee is well aware of what Borg-Warner versus Flores was. In a nutshell, a plaintiff got a verdict from a jury under their claim that they got asbestosis from some asbestos-containing friction products, principally clutches, and it was reversed ultimately by the Texas Supreme Court, saying that it did not meet our causation standards. And at that time, the Texas Supreme Court created a new causation standard. What I want to be clear about is there was no requirement before that time that a plaintiff in an asbestos case have to count the number of asbestos fibers they were exposed to from a product, microscopic as they are, 40 years ago. It was only with that case and that decision that that new standard was created. At the same time, the court adopted the Lorman standard, the frequency, proximity, and regularity standard, which has been discussed, of course, as the majority rule around the country, but said both of those requirements are necessary. Not only must the plaintiff meet the Lorman standard, but to prove substantial factor, they have to then count the number of asbestos fibers they were exposed to as to the product that many years ago, compare it to epidemiology, show that in comparison to cohorts in epidemiology, they have this increased risk, and so forth. Now, what the court noted in Flores that's important is that asbestosis had a discernible threshold of asbestos exposure. It took a lot of asbestos exposure, which they pointed out to be 25 fiber years. Without getting in the minutia of that, it's a lot. The court understood that mesothelioma is different. There is no known minimum safe threshold. People throw that around, but I want to talk about what that means. However close to zero asbestos exposure it takes to induce mesothelioma, it is so small it has never been quantified with certainty. It's not that it's so high that we can't get our arms and heads around it. It's that because over and over and over it has been established in medical and scientific literature that even the briefest asbestos exposures can induce the disease. And so anytime a person has mesothelioma, you have a tort. The only issue is whether or not there is a liable party, because people aren't supposed to get mesothelioma. The answer to the question which was posed by Representative Jackson earlier is, was there mesothelioma prior to the manifestation of asbestos in our economy in the industrial age going up into the 1970s? And the answer is not really. Not really. There were some reports of what was called pleural cancer, which is where that disease arises, but it is undeniable that asbestos exposure is the cause of mesothelioma and our understanding of how that disease has occurred in the United States and elsewhere. So, when the Stevens case came forward, the facts of that case was that Mr. Stevens was a painter, and as a painter, he was exposed to asbestos-containing construction products. And the construction product he was most principally exposed to was joint compound used for taping and bedding the seams and wallboard. And the testimony in that case was that he was exposed to a lot of several different joint compounds. Again, to take up Representative Jackson's point, it's a classic case where a guy really was exposed to a whole lot of different asbestos products, because that was the nature of his job. What the court found on appeal in the Stevens case is that although the testimony was irrefuted that he was exposed to a lot of the Georgia-Pacific asbestos-containing joint compound over the course of his career, that there was no way to discern from the evidence how many times that was. And because we didn't know how many times that was and how long that occurred, the dose couldn't be quantified, so we couldn't compare it to a threshold, which assumes in the first instance there is one, and therefore he lost. The jury verdict was reversed. The issue now is in the Smith case, we have a standard that as a practical matter, no Texan should be asked to meet, and that no other state requires its citizens with mesothelioma to meet. The facts of the Smith case are illustrative, and that's why I want to focus on it for just a moment if I could. Mr. Smith was a drywaller, worked in Texas. He worked with joint compound and around joint compounds his entire professional career, which spanned many decades. He was exposed to several different brands of joint compound because that's the nature of that kind of work over the course of a long career. The product at issue was a product made by Kelly Moore. It was a joint compound. It contained asbestos through 1978. There was no dispute about that. And that he was exposed to that particular product on the order of hundreds or thousands of times. It was clear that it was hundreds. It may have been thousands. That the exposures to that product exceeded the OSHA limits for what is permissible. So the product violates OSHA limits, which are there to protect against diseases such as the ones that he got. And that this occurred for decades. Not only that, but his lungs were full of chrysotile asbestos. And it was perfectly clear that he died from exposure to chrysotile asbestos that caused his cancer. And that the Kelly Moore product at issue contained chrysotile asbestos that he was exposed to hundreds of thousands of times. And that his exposure was above permissible limits. And the court concluded, well, you have sufficiently quantified dose. You clearly have a dose that is above a background level, and you have attached a number to it to our satisfaction. But then the next requirement was that they compare it to epidemiology. Can you, the plaintiff, now show that your exposure was higher than what's been shown to cause mesothelioma in epidemiological studies? He had 2 studies, both of which showed mesothelioma was caused by asbestos exposure at levels lower than his exposure to the Kelly-Moore joint compound. He's got it. Before I get to the court ruling, I want to talk about just the common sense issue of this. He has lungs full of the kind of asbestos that everybody agrees was the cause of his death. From a lifetime of working with products like the one at issue, to which he was exposed a lot, sufficiently quantified. Of course, we would say, I hope from a common sense standpoint, that a reasonable jury would conclude, sure, you could conclude that was a substantial factor. The answer was no, you couldn't. Because the epidemiology that he relied upon was not specific and only to the chrysotile asbestos in the Kelly-Moore product, so he lost. Never mind that those studies don't exist, and never will, because we don't expose people to asbestos like that anymore. He couldn't win because he was the plaintiff, having to meet that standard. I know I just have a few seconds. I'd like to make this point quickly and then make a closing comment. The Borg-Warner standard is not the modern trend in jurisprudence around the United States in dealing with mesothelioma. Lorman is the relief that we are asking for. The frequency, proximity, and regularity test was created to protect against the any exposure theory. That's what the case law says. It's to protect against the mere trivial or inconsequential exposures because they have to be frequent and proximate and regular, and that's its purpose. And all around the country, these states are rejecting...
Go ahead and sum up because I'm giving you a little bit more time.
They're rejecting around the country the requirement, which is always urged by defendants on appeal, which is always urged by amicus briefs, especially by groups like the Coalition for Litigation Justice, who may testify today. They're always saying you should quantify dose like Texas does, and around the country they're saying no, we shouldn't, that's not right. And my last comment is this, and I thank you, the chairman, for your indulgence. I am certainly have been around the town a little bit, and I understand that I'm here as a trial lawyer with all the obvious and perceived biases that go with that political identity. I'll stipulate to all of them. But as I said, I've spent my whole life professionally representing people with mesothelioma, and what I can say about them is they have no singular political identity. Some are Republicans, some are Democrats, some are independent, some are Tea Party, some have no political affiliation at all. But what they all have in common in this state is they will die of the asbestos exposure they have. Their state treats them worse under the law than every other state in the union does. And they need your help. Thank you.
Okay, thank you. Thank you very much. All right, next, Scott Brister.